Hello, hi guys. This is 𝗙cie Balakrishna from lecturepedia.in. How are you? Hope you people are doing well. Even I am fantastic. In the today's class, we'll be starting with the fifth chapter from the Companies Act. That is compromise, arrangement, and amalgamation. Basically, this chapter it is a very small chapter and easy to understand. And the weightage of this chapter it would be 2 to 3 marks. Okay, for your set a SPOM. Now before entering into the chapter, let us first of all understand these terms. What is meant by compromise, what is meant by arrangement, and amalgamation. I guess you might be already knowing what is meant by amalgamation. However, I will be discussing again here in this class also. Okay, so starting with the first term, compromise. Now, when will a compromise be entered? Let's say there are two parties. If there is a dispute between these two parties, then they might come to a compromise on that dispute, right? So, compromise will occur when there is a dispute, right? So, the same thing will be applicable even here in this Companies Act also. But here the compromise will be between three parties. Okay, Companies Act, this chapter deals with compromise among three parties. Okay, in the compromise that we are going to discuss here in this chapter, only three parties will be involved. Who are those three parties? First of all, if there is any dispute between company and creditors, then these two people, company and creditors, can enter into compromise. Or dispute can be between company and members. Members means shareholders. Okay, even if there is any dispute between company and shareholders, they can enter into compromise as per this chapter. Okay, so here in this chapter, the three parties that will be involved is company, creditors, members. Okay, the dispute can be between company and creditors or company and members. Okay, in that situations, for making compromise, you can apply this chapter. If there is dispute between creditors and members, then this chapter is not applicable. Okay, only if there is dispute between company and creditors or company and members, that is for compromise between company and creditors or for compromise between company and members, the compromise will take place as per this chapter, as per provisions of this chapter. Hope you are clear with this. So compromise will occur when there is a dispute. I hope you understood what is meant by compromise. Let's say, for example, in the books of accounts of the company, it is showing that company has to pay 2 crores to creditors as per books of accounts of the company. But creditors are saying that company has to pay 2.5 crore as per the records of the creditors. Now, if you see, there is a dispute between company and creditors. Now, this dispute, it can be resolved with the help of compromise. Okay, we will be discussing section number 230, 230, all these sections. Okay, in the same way, dispute between company and members. Next, arrangement. The next term that we are going to discuss is arrangement. Now, if you see the compromise that we have discussed now, the compromise is also one type of arrangement, but in case of arrangement there will not be any dispute. Okay, In case of arrangement, no dispute between the parties. Let's say, for example, yeah, company. In the books of accounts of the company, it is showing that company has to pay 2.5 crore to the creditors. And on the other side, even in the books of accounts of the creditors also, it is showing that company has to pay 2.5 crore. Here there is no dispute, but company is not in a position to pay entire 2.5 crore. So what the company said is, it will pay only 2 crores to creditors, and balance 50 lakhs is there na, that has to be written off. So company has entered into this type of arrangement with the creditor. Here there is no dispute, but there is a arrangement. Okay, so in case of arrangement, there will be alteration or modification of the existing terms and conditions. Okay, so you will be calling this as arrangement. Hope this is clear. Arrangement is a broader term. Compromise is one type of arrangement where dispute will be involved. Hope you are clear with this difference between compromise and arrangement. Okay. Yes. And amalgamation, you already know. Amalgamation means merging of two companies. Okay. A Limited, B Limited. They have merged and formed AB Limited, or A Limited, B Limited. A Limited has merged into B Limited. That we will be calling as amalgamation, right? If you see the definition or the understanding of compromise, it means to settle disputes between company, creditors, members. Okay, between company and creditors, between company and members, not between creditors and members. Hope that is clear. You should remember this. Next, arrangement. In case of arrangement, there will not be any dispute. Arrangement involves modification or adjustment of rights of creditors or members. Okay, there will not be any dispute, but it involves certain changes, certain modifications, certain alteration of rights and obligations of creditors or members. And arrangement is a broader term. Compromise is one type of arrangement where dispute will be involved. Hope that is clear. See, note, arrangement is wider term. Compromise is also a type of arrangement. Now, the company and creditors, or the company and members, they wanted to enter into a compromise, or they wanted to enter into a arrangement. Now for this arrangement or for this compromise to take place, the approval of tribunal is required. Okay, application to the tribunal has to be made under section 230. Basically, if you see, this entire chapter is there na, compromise, arrangement and amalgamation. It is a procedural chapter. That means this chapter mainly discusses about the procedure that has to be followed for entering into compromise or arrangement or a amalgamation. So these sections are procedural sections. There will not be much analysis that will be involved in these sections. Okay, the procedure will be there, like to whom you have to make the application, along with the application what annexures has to be given, and to approve the application how many number of persons has to agree to it, right? So these type of procedural aspects will be there in this chapter. Hope that is clear. Now if you see section number 230, starting with section number 230, basically section number 230 deals with procedure that has to be followed for entering into a compromise or an arrangement between company and creditors or company and members. Okay, see, section 230 is applicable for entering into compromise or arrangement, okay, for both of these same section with creditors or members. Okay, so for compromise or arrangement, the common party will be the company. Okay, company will be always standard. It could be either with creditors or with members. Members means shareholders. Okay, company will be constant. Okay, company will be constant party to the compromise or arrangement. Now we'll see there will be 4 steps. I have divided this procedure into 4 steps. What are those 4 steps? Let us see. First of all, you have to make an application to the tribunal. See, application for compromise, let me use another pen, compromise or arrangement by company, creditors, members or liquidator. Okay, application has to be made by these people. To whom? To tribunal, by any of these people. Okay, now here why liquidator has come? Because sometimes company might be in liquidation and there might be dispute with the creditors. In that situation, liquidator will make an application to the NCLT, that is to the tribunal regarding this compromise or arrangement. So liquidator can also make an application to the tribunal for compromise or arrangement between company and creditors or company and members. Hope that is clear. That is the reason why liquidator has also been kept here. So what is the format in which the application has to be made? The format is NCLT 1. Okay, now once application has been made to the tribunal regarding this compromise or arrangement, what the tribunal will do is tribunal will ask the company to call for a meeting of creditors or members. See, here the compromise is between company and creditors or members. So to take place the compromise or arrangement, all these people, they have to come together and they have to discuss, right? For discussion, a meeting should be called. That is what the tribunal is ordering for. Tribunal will order to call a meeting. Okay, so what is the first step? The first step is application for compromise or arrangement has to be filed. In which form? In form NCLT 1. By whom? Either by company, creditors, members or liquidator. To whom the application has to be filed? It has to be filed with tribunal. Once application has been filed with the tribunal, what the tribunal will do? Tribunal will order for conducting meeting of either creditors or the members based on the parties involved in the compromise or arrangement. Now along with this application that you are filing with the tribunal, you should give following annexures. What are those following annexures? First of all, basic details related to the company. See, disclosures that has to be given along with the application. There are 3 disclosures that has to be given. What are they? All material facts about the company, like the latest financial statements of the company, the business activity of the company, annual return of the company, like this, the directors of the company. So the basic info of the company should be given to the tribunal. Next, any reduction of share capital. Okay, whether this compromise or arrangement involves any reduction of share capital. Now what is meant by this reduction? Basically, I will be discussing the reduction and buyback, the difference between reduction and buyback of shares here. Okay, here I will discuss what is difference between reduction and buyback. Okay, so you just remember that along with the application, if at all this compromise or arrangement involves a reduction of share capital, you have to give the annexure of this reduction of share capital. Also you need to disclose that this compromise or arrangement involves reducing shares of the company. Okay, as an annexure to the application, you have to give this disclosure. Next, whether this compromise or arrangement involves any corporate debt restructuring scheme consented by not less than 75% of secured creditors. What is corporate debt restructure scheme? Let me tell you. Let's say company has taken loan. Okay, company has taken loan from creditors. Now, the amount of the loan is 30 crores. Rate of interest is 14%. Repayment tenure is 10 years. Okay, so these are the original terms of the debt that the company has taken with the creditors. Now, company is entering into a compromise or arrangement with the creditor which involves restructuring of this debt that the company has taken. Restructuring means, let's say, changing the rate of interest from 14% to 12%, or changing the tenure from 10 years to 15 years. So restructuring the debt means changing the original terms of the debt is known as debt restructuring. Since a company is involved here, you will call it as corporate debt restructuring. Okay, now if the compromise or arrangement involves any such corporate debt restructuring scheme that has been consented, that means that has been approved by 75% or more of secured creditors, then you have to disclose this fact as an annexure. Okay, now if corporate debt restructuring is involved, you should also submit following details. What are they? Firstly, you should give creditor responsibility statement. Okay, see, along with the application for compromise or arrangement to the tribunal, you have to annex this corporate this creditor responsibility statement if at all corporate debt restructuring scheme is involved. Okay, now what will be there in this creditor responsibility statement? The following 4 things will be there. See, safeguards to protect other creditors. Okay, terms and conditions with respect to the corporate debt restructuring scheme will be involved in this creditor responsibility statement. Okay, the first thing is any safeguarding provisions to safeguard the interest of other small creditors. Next, auditor report that the company confirms liquidity test. That means liquidity test means the company is in liquid position. The company is able to repay its liabilities with the help of the assets that the company is having. This liquidity test that the company is in liquid position only, like this a certificate has to be given by the auditor. Even that certificate will also be forming part of this creditor responsibility statement. Next, that company will comply with the guidelines issued by RBI. Okay, creditor responsibility statement should also include that company, while entering into this corporate debt restructuring scheme, will comply with all the guidelines that has been issued by Reserve Bank of India and valuation report by registered valuer. Okay, the valuation report of assets of the company should also form part of this corporate responsibility creditor responsibility statement. And this valuation, it will be obviously done by registered valuer. Okay, why the valuation of assets is required? Because company is restructuring its debt. In case of restructuring, mostly reduction of debt will be involved. The changing of the terms in favor of the company will be involved, like reducing the rate of interest or increasing the tenure of repayment. These type of things will be involved. Now here, creditors are allowing the company to reduce the rate of interest. Why? Because company is in bad situation. Company is not able to repay the debt. So to prove that really the company is in bad situation, company has to submit the valuation of its assets. What is the valuation of its assets? Let's say, for example, company has to pay 30 crores to the creditors, and the company is having assets worth 1000 crores. In such a situation, why will creditors offer reduction in rate of interest, or why will creditors offer increase in a tenure of repayment? Because company is having 1,000 crores assets, it can sell off some of its assets and repay the creditors, right? So to check this aspect, creditors will also ask for this valuation report of assets of the company from a registered valuer. Hope that is clear. So that is the first step, which involves application to the tribunal. Next, second step, once the application has to be made to the tribunal, what the tribunal will say? Tribunal will ask the company, okay company, now you call for the meeting of creditors or the shareholders for approving this compromise or arrangement. First of all, creditors or the members, they have to approve the compromise or arrangement now. So call their meeting, like this tribunal will say. Now company has to call the meeting. In order to call the meeting, what the company has to, it has to give a notice of meeting, right? So step 2 is that only, giving notice of the meeting shall be sent by the company. Notice of meeting of the meeting shall be sent by the company to creditors, members, debenture holders, sectoral regulators. Sectoral regulators means SEBI, Securities Exchange Board of India, RBI, stock exchanges and registrar, income tax authorities. They will be coming under sectoral regulators, government authorities. Okay, so the company will send the notice of the meeting to the creditors. Okay, if the compromise is with the creditors, it will be sent to the creditors. If the compromise is with the members, it will be sent to the members. Okay, debenture holders are also one type of creditors only, and to sectoral regulators. Now to this notice, and here in case of sending notice to the sectoral regulators, require representation if any within 30 days. Okay, if sectoral regulators wanted to communicate anything with respect to these meeting, they have to communicate it within 30 days. Okay, they have to give the representation in 30 days. And along with this notice of a meeting, company should send details of compromise or arrangement. See, you are sending notice of meeting to the members of creditors, they will come to the meeting. In the meeting they have to discuss na. In order to discuss, they should have the facts related to the compromise or arrangement. So along with the notice, you will send details of compromise or arrangement, so that they will prepare, and if they have any questions, they will ask in the meeting. So you should send details of compromise or arrangement along with the notice of the meeting. Next, valuation report if any, and effect of compromise on creditors, key managerial personnel, promoters, debenture holders, etc. Okay, if this compromise or arrangement is entered, what effect will be having on the creditors, what effect will be having on the key managerial personnel, what effect will be having on the promoters. So this impact should be clearly disclosed or clearly given as a annexure to the notice of the meeting. Like if this compromise is entered, creditors will lose 2 crore rupees because of compromise. That is, let's say in the compromise the rate of interest is being reduced, or in the arrangement the rate of interest is being reduced. So because of this arrangement, where rate of interest has been reduced from 14% to 12%, the creditors will incur a loss of 2 crore. So that is the impact of arrangement on the creditor. You need to clearly disclose this impact on all the affected parties. Hope that is clear. So this is sending of notice, and this notice of meeting should also be advertised by the company. See, advertisement of the notice, where will you advertise? On the website of the company. Okay, the company is having the website, on the website of the company you need to advertise this notice. And if the company is a listed company, then you should also advertise this notice on SEBI's website and stock exchanges website. Okay, you need to send notice of this meeting to the SEBI and to the stock exchanges. They will advertise this on their websites and newspapers. Okay, so company has to advertise its notice in these places. Now let's say, for example, company has or company wanted to enter into compromise or arrangement with creditors members. If 90% of value of creditors agree for the compromise, in such a situation you need not call for meeting. Okay, see, tribunal can dispense with calling of meeting of creditors if 90% of value of creditors agree and confirm to the scheme by way of affidavit. Okay, now company wanted to reduce the rate of interest to 12% with creditors. So this is an arrangement. Now, for this arrangement to happen, you have to make an application to the tribunal. Okay, once you make an application with the tribunal, what the tribunal will say, tribunal will ask for conducting the meeting of creditors. Now, if you want to conduct the meeting, some expenditure will be involved. So, in order to avoid that expenditure, what the company can do is, if 90% of value of these creditors, let's say total creditors are 100 members are there, and to these 100 members company owes some 1000 crores. Okay, so of these 100 members to whom at least 900 crores is being owed. Okay, if such number of members give an affidavit to the company, okay, affidavit in a written format that we agree to this arrangement, in such a situation you need not call for meeting. Okay, in such a situation tribunal will dispense off with the requirement of a calling of a meeting of creditors. Hope that is clear. However, this option is not available for shareholders. Okay, if there is any compromise or arrangement with the shareholders, this option of dispensing off with meeting of shareholders is not available. If the compromise or arrangement is with creditors and 90% of value of creditors agree for this compromise or arrangement through a affidavit, then tribunal can dispense off with the requirement of calling of a meeting of creditors. Hope that is clear. So this option is available only for the creditors, not for the shareholders. So that is step number 2, which deals with notice. Next, step number 3, which is with objection to compromise or arrangement. Obviously, once you send a notice of a compromise or arrangement, it is not required that all the people will agree with the compromise or arrangement. Some people will agree it, some people will disagree with it. So if there is any objection to such a compromise or arrangement, within 1 month from the receipt of notice, in case of members holding 10% or more of the shareholding have to object it. Okay, if the compromise or arrangement is between company and members, then within 1 month of giving of notice, members holding at least 10% or more shareholding can object to the compromise or arrangement. Okay, if that many number of shareholders have not objected, then it will be approved basically. Next, in case of creditors, okay, if the compromise or arrangement is between company and creditors, then in order to raise objection for the compromise or arrangement, creditors holding at least 5% of the total outstanding debt has to raise an objection within 1 month. Again, here also time limit will be same. Okay, so in case of members it is 10% of value of shareholders. In case of creditors it is 5% of the total outstanding debt. Hope that is clear. Next, if no one is having objection, okay, no one is having objection with the terms of the compromise or arrangement, in such a situation it can be approved. So for approval, the compromise or arrangement has to be approved by majority persons representing 3/4 in value. If you see here, for approval there is a dual requirement. One is majority persons and 3/4 in value. It is very important for MCQ purpose. Let me tell you. Let's say for example, compromise or arrangement is with or is between company and creditors. Okay, let's say company wanted to reduce rate of interest to 12%. Okay, now if for this compromise or arrangement any creditor is having objection, okay, to raise objection. Objection means they are not rejecting the scheme, but they are having an objection. What type of objection? They are not okay with 12%. They wanted 13%. Okay, from 14%, they are okay to reduce to 13%, not 12%. So this is an objection. They are okay with the scheme subject to certain conditions. Okay, so this is objection. So to raise the objection, how many creditors? At least 5% value of outstanding debt creditors has to raise a objection in order to raise the objection. Okay, next, approval of the scheme. Let's say there are total creditors, total number of creditors or 100 creditors. Okay, 100 number of creditors are there, and outstanding debt amount, is 1000 crores. Now in this situation, to give approval for this compromise or arrangement, majority creditors. So majority means of 100 creditors, majority means 51 creditors. 51 creditors should approve, and here it is not or, and 3/4 of value. Now in terms of value, 1000 crores. Of 1000 crores, 3/4 means 750 crores, more than 750 crore. So majority creditors holding 3/4 of value must approve. Okay, that means at least 51 creditors or more creditors holding at least 750 crore or more has to give approval in order to approve the compromise or arrangement. Hope that is clear. Now let's take a situation. Now these many creditors have approved it. Okay, but an objection has been raised by certain 6% of certain creditors who are holding 6% outstanding debt. Now in this situation, tell me whether this objection will be taken up. The answer is no, this objection will not be taken up, because the scheme has already been approved by this many number of the required amount of creditors. Approval has been received already. Since approval has been received, even though objection is raised by certain number of creditors, it will not be taken up. Okay, next, approval is not yet received. Okay, approval is not yet received, and objection is raised by 6% number of 6% outstanding value of creditors. In this situation, whether objection will be taken up or not? Yes, the objection will be taken up. Hope this is clear. If approval is received, then need not worry about the objection. If approval is not received, you have to take care of that objection. Okay, Let's say approval is not received, but it has been objected by creditors holding 4% value of debt. In this situation, this number of creditors are first of all not eligible to raise the objection itself. Since they are not at all eligible to raise the objection, company need not care about the objection that they have raised. Hope that is clear. Okay. So this is the interlinking between those 2 points. And once tribunal sanctions, after the creditors or members have given approval to the scheme, tribunal will also sanction the scheme. And once the tribunal will sanction the scheme, it will be binding on all the parties to the compromise or arrangement. Hope that is clear. And finally, step number 4. Step number 4 involves file the order of tribunal with registrar within 30 days. Now, tribunal has given order of compromise or arrangement to the company. Now, this order has to be filed with the registrar of companies, ROC, within 30 days. That we have received the approval for the compromise or arrangement. Note, compromise or arrangement involves, if the compromise or arrangement involves reduction in share capital or buyback of shares. First of all, what is the difference between reduction of share capital and buyback of shares? First of all, buyback. Buyback means you already know. Company will purchase the shares of the company from the shareholders. Right here, company will give money to shareholders, and from shareholders it will take shares. This is buyback, you already know. Coming to reduction, now reduction can occur in some 2 situations. Let's say company, shareholders. Now, in case of reduction, there can be 2 possibilities. First of all, if company wants, company can pay money, or if company wants, company will not pay money also. Okay, no money paid to the shareholders. In case of reduction, company can cancel the shares of the shareholders without paying any money. Why? Let's say one situation, the assets of the company are 100 crore. Okay, but the shareholders, the shares value is there, no? It is 150 crore. So in this situation, the balance 50 crore, for this there is no respective asset, so it can simply cancel those shares. Okay, since there are no assets with the company, this is one of the situation in which capital will be reduced. Reduction of capital will happen without payment of any money to the shareholders. Or let's say, basically let's say the face value of each share is 10 rupees. Now these shares are partly paid up shares, like 5 rupees has been paid on these shares, still 5 rupees is not paid. Now in this situation, what the company can do is to cancel these partly paid up shares. It cannot go through buyback option because these are still not fully paid up shares. So to cancel these shares, company can use this reduction of share capital mode. Okay, here company can repay that 5 rupees to the shareholders and can cancel this partly paid up shares. So for cancellation of partly paid up shares, company will use this reduction of share capital option. Okay, so that is the difference between reduction and buyback of shares. Hope that is clear. Now, if you see, there are two different sections for these two options. You have already learned them at your CA Inter level. Basically, section number 66 deals with reduction of shares. Section number 68 deals with buyback of shares. If you see, this reduction of share capital, buyback of shares is also one type of arrangement that the company is entering with the members, right? This is an arrangement. Now, if the arrangement involves reduction of share capital, then company need not comply with section number 66. It is sufficient if it just complies with this process of section number 230. Okay. Next, if in case the compromise or that arrangement involves buyback of shares, then company should comply with, okay, must comply with section 68 along with this section 230. Hope that is clear. Okay. Next, section number 231, power of tribunal to enforce compromise. See, once a tribunal has ordered the compromise or arrangement, it is having the power, certain powers to enforce this compromise. What are they? It can supervise the implementation of compromise or arrangement. It can give directions to the company creditors members regarding this compromise or arrangement. And if the tribunal feels that this compromise or arrangement that it has ordered cannot take place, cannot be implemented, in that situation tribunal can also order for winding up of the company. See, if compromise or arrangement cannot be implemented, then pass winding up order. Okay, yes, that is section number 231, which deals with powers of tribunal to enforce this compromise or arrangement. Next, section number 231, 232, which deals with merger or amalgamation. Now, if you see, the application for this merger or amalgamation has to be made under section number 230 only. Okay, and in section number 230, the company has to prove that there is a requirement for the amalgamation or merger, okay, to the tribunal. If tribunal also feels that there is a requirement for the amalgamation or merger, then it will order for the merger or amalgamation of the companies. See, application for merger or amalgamation has to be made under section 230. That is the way in which you will make an application for compromise or arrangement. In the same way, you have to make the application for amalgamation with the tribunal. Okay, and provisions related to notice of meeting, approval, objection will be same. Okay, that for raising objection 5% of creditors, 10% of shareholders, and for giving approval majority in person holding 3/4 of the value, all those provisions, sending notice, advertising that notice, okay, all these provisions which we have discussed in section number 230 will be mutatis mutandis applicable even for section number 232 with respect to the merger and amalgamation also. Hope that is clear. Now, if you see this amalgamation or merger, it can happen in two ways. Let's say A Limited plus B Limited can become AB Limited, or there is A Limited, there is B Limited. A Limited can come and merge with B Limited, resulting only in B Limited. Okay, here in the first situation, both A Limited and B Limited will be liquidated. In the second situation, A Limited will be liquidated and A Limited will merge in the B Limited. Okay, so this way the amalgamation or merger can happen. Now, if in case the notice of meeting is with respect to this amalgamation or merger, then along with the notice you have to give following annexures. In case the notice is with respect to normal compromise or arrangement, you have given the normal disclosures like basic details of the company, whether this compromise or arrangement involves any corporate debt restructuring scheme. Okay, those annexures you have given in section 230. If in case that notice is with if in case the notice of meeting is related to discussion of amalgamation or merger, then along with that notice of meeting you have to give following annexures. What are they? See, annexures along with notice of meeting. Basically these annexures, they will be related to the terms and conditions of merger or amalgamation. See, proposed terms of the scheme, because shareholders after coming to the meeting, they have to raise their queries, they have to participate in the discussion. In order to participate the discussion, they have to know the facts of the scheme, right? The facts of the amalgamation or the merger. So you have to send proposed terms of the scheme, so that the shareholders, they will read that terms in their house and they will come for the meeting. Okay, next, confirmation that copy of scheme filed with the registrar. Okay, along with the notice of meeting, you should also give a confirmation to the shareholders or the creditors, stating that we have filed this copy which we have sent to you to the registrar of company, to the ROC also. Such confirmation has to be given. Next, effect of compromise on key managerial personnel, promoter, shareholders, etc. Okay, what will be the effect of this amalgamation or merger on different parties? You have to mention that. Next, valuation report from expert. Okay, supplementary account statement. All these you need to give along with notice of meeting for a merger or amalgamation. Now, if the after giving notice of a meeting, in the meeting, if this merger or amalgamation is approved, then it will be furnished to the tribunal, and tribunal will pass order of amalgamation or merger, right? And this approval, all that, the same provisions of section 230 will be applicable for approval majority in members 3/4 value. Okay, the same provision will applicable even for section number 232 also. Now, the order that the tribunal will give now approving the amalgamation or merger, what will be there in the order of the tribunal? Date of transfer. Okay, from which date this transfer will be effective? Payment of purchase consideration. Okay, how much purchase consideration will be paid, and in what dates it will be paid, and in what form it will be paid. Okay, the details with respect to purchase consideration will also be there in the order of the tribunal. Next, continuation of legal proceedings. Now, A Limited, B Limited, two companies are merging. Now, on A Limited, there might be some pending legal proceedings, pending cases. On B Limited also, there might be some pending legal proceedings, legal cases in the court. What will happen to those cases after A Limited and B Limited has been liquidated and AB Limited has been formed? That will be mentioned in the order of tribunal. What will happen? Basically, those pending cases will be transferred onto the AB Limited, right? So even this point will be mentioned in the order of tribunal regarding what will happen to the legal proceedings. Next, provision for dissenting shareholders. Okay, dissenting shareholders means shareholders who have not agreed for amalgamation or merger, they will be known as dissenting shareholders. Okay, what will happen to those shareholders who have not agreed for amalgamation or merger? Even this will be mentioned in the order of tribunal. Next, set off of fee paid for authorized share capital. Now let's say, for example, A Limited has authorized share capital of 1 lakh rupees, B Limited has authorized share capital of 10 lakh rupees. Now, AB Limited also should have some authorized capital, right? Authorized share capital. Let's say it has kept its authorized share capital as 11 lakh rupees. Now, for this authorized share capital, AB Limited again need not pay fee to the MCA. Okay, the fee that has already been paid by A Limited and B Limited will be set off for the fee that has to be paid by the AB Limited for its authorized share capital. Hope that is clear. Basically, you might be knowing this, right? For getting the authorized share capital, you need to pay certain minimal fee to the MCA. Based on basically the fee that MCA charges you for incorporating the company will change based on the authorized share capital, right? It will be just a minimal amount that will be charged. Next, transfer of employees. What will happen to the employees? Okay, the employees of A Limited, employees of B Limited, they will be transferred to the AB Limited. Okay, even this point will also be mentioned in the order of tribunal. And once order is passed by tribunal, assets and liabilities of transferor company becomes assets and liabilities of transferee company. Okay. Order of tribunal shall be filed with registrar within 30 days. Okay. With the registrar of company, you have to file the order of tribunal within 30 days of receiving the order. Next, every year file statement of compliance with registrar signed by CA or CMA or CS till completion of the scheme. Now, in some situations, the process of this amalgamation or merger will happen for more than 1 year. Okay, in case of large corporate companies, in order to transfer all the books of accounts and in order to transfer all the procedural aspects, it might take some 2 years or 3 years. In such a situations, at the end of each year, you need to file statement of compliance with the ROC, which is signed by CA or CMS, stating that they are complying with the terms of the order of the tribunal. Okay, statement of compliance means the company in the process of amalgamation or merger, they are following all the terms and conditions that have been given in the order of tribunal. That is known as statement of compliance. This statement of compliance has to be filed every year with the registrar till the completion of this scheme of scheme of amalgamation or merger. Hope that is clear. Next, section number 239, preservation of books of accounts. Now, A Limited, B Limited, they have merged and they have become AB Limited. Now, there will be books of accounts of A Limited, there will be books of accounts of B Limited. What will happen to books of accounts of A Limited and B Limited? Whether these books of accounts they can be disposed of? The answer is, before disposing of the books of accounts of these two individual companies, you have to ask for permission of central government. Once you ask for permission of central government will conduct a investigation of these books of accounts and it will issue order for disposing the books of accounts. See, books of accounts of amalgamated companies shall not be disposed of without prior permission of central government. Okay, and central government appoints a person to examine books of accounts if any fraud taken place before granting the permission, because there might be a possibility that A Limited, it might have conducted some fraud, and to get away with that fraud, A Limited might be merging with B Limited. Okay, once A Limited merges with B Limited, both will combine and the books of accounts and entire history of A Limited will be wiped off. So there is this possibility. So to detect such a possibility, before disposing of books of accounts of A Limited or the B Limited, central government will appoint a person to clearly investigate, to clearly go through books of accounts of the company to find out any fraud. If no fraud is found, then central government will order for disposing the books of accounts of the company. Hope that is clear. Next, section number 240, liability of officers of transfer or company for offences committed prior to merger will continue. Now, see, A Limited, B Limited. Now, in the A Limited, the employees, certain employee has committed certain fraud. Now, before merger, this fraud has taken place. AB Limited is formed. After forming AB Limited, this fraud has come out. Now, in this situation, this employee will be responsible. Okay, as per section number 240, liability of officers of transfer or companies for offences committed prior to merger will continue. Okay, their liability will not extinguish. Okay, next. Section number 234, merger of a foreign company with Indian company. See, even if a foreign company is merging with the Indian company, the same procedure that we have discussed in section 232, that is conducting meeting of shareholders, making application to the tribunal, approval by majority 3/4 value, all those provisions will apply mutatis mutandis, provided along with those provisions prior approval of RBI is required. Okay, you have to take prior approval of Reserve Bank of India if you want to merge foreign company with the Indian company. Hope that is clear. All the provisions will apply mutatis mutandis. However, prior approval of RBI is required. Next, section number 237, power of central government to provide for amalgamation in public interest. Now, in some situations, what might happen is, in the public interest, central government can order for amalgamation of companies. Let's say, for example, Satyam. Let's say Satyam scam has come out, and because of that scam, if Satyam company has been liquidated, then there will be lot of impact on the economy. Okay, there will be lot of impact on the employees that are working. Around more than 2 lakh employees were working in the Satyam. So to avoid such type of disaster, what the central government can do is, in the interest of public, it can order for amalgamating or merging Satyam company with some other software company, right? So in such situations, central government will order for amalgamating the companies in public interest as per section number 237. Now, by ordering official gazette, by making an order in official gazette, central government will enforce this. Next, proceedings against transfer or company may continue against transferee company. Okay, if at all there are any legal proceedings pending against the transferor company, they will continue on the transferee company. Okay, they will be transferred to the transferee company. Next, rights and interest of members, creditor, debenture holders of the transferor company shall remain same. Otherwise, compensation will be given. Okay, whatever the rights the members, the creditors are having in the transferor company. Let's say Satyam is a transferor company. If Satyam has to pay some 100 crore to the creditor, here the creditors of Satyam company are having right to receive 100 crore from Satyam company. Satyam company merging with some other company. In this situation, the creditors of Satyam company will be having same right to receive that 100 crores from this new transferee company. Hope this is clear. If in case there has been any reduction in such rights, then compensation will be given for such reduction of rights. If the person is aggrieved with the compensation, then you can file an appeal to the tribunal within 30 days. Okay, if the creditors or members or any other person is not, have not accepted or not satisfied with the compensation that has been given, compensation that has been awarded, then they can file an appeal with the tribunal within 30 days. Hope that is clear. Next, once that order has been passed in the official gazette, copy of order shall be presented before each house of the parliament. Since this amalgamation is being taking place in the interest of the public by the central government, it has to be placed before the houses of parliament. Okay, next, section number 235, which deals with power to acquire shares of dissenting shareholders. Now let's say A Limited wants to acquire B Limited. Now in that situation, A Limited can give offer to the shareholders of B Limited stating that, shareholders, we wanted to take over your company. So whether you will sell your shares to us. See, transferee company. Transferee company means the company who wanted to take over. Transferor company. Transferor company means company to whom the offer is being given. Now, transferee company can offer to acquire transferor company to the shareholders. Okay, to the shareholders of transferor company, transferee company will give a order, will give a offer whether you are willing to sell your shares. Now, if for such offer 9/10 value of shareholders agreed within 4 months, okay, within 4 months of giving the offer to the shareholders of transferor company, 9/10 of value of shareholders have given approval for the offer. That means shareholders who are holding 9/10 of the value are ready to sell the shares to the transferee company. Let's say total share capital is some 1000 crores. Of that 1000 crores, 9/10 means shareholders holding at least 900 crore worth of shares are ready to sell their shares to the transferee company, that within 4 months of giving the offer. In such a situation, see, and in this situation, whether there are any dissenting shareholders, if there are no, whether this many number of shareholders have approved, okay, whether this many number of shareholders are ready to sell the shares. If this many number of shareholders are not ready, no, in such a situation transferee company cannot acquire. Okay, since the 9/10 of value of shareholders are not ready to sell the shares, transferee company cannot take the company, okay, cannot take the transferor company. If yes, okay, if 9/10 of value of shareholders are ready to sell the shares, in such a situation, if there are any dissenting shareholders, okay, it is not possible that all the shareholders will give their approval. There will be some dissenting shareholders. If at all there are any such dissenting shareholders, and such dissenting shareholders have filed an application with the tribunal stating that we are not ready to sell our shares to this transferee company, like this they have filed application with the tribunal. In such a situation, you have to do whatever the tribunal says, do as per the tribunal's order. If the dissenting shareholders have not filed any application with the tribunal, no application filed with the tribunal, in such a situation transferee company is bound to acquire the shares of the dissenting shareholders also. Okay, if dissenting shareholders have not filed an application with the tribunal, in such a situation transferee company will be having the right to acquire the shares of the dissenting shareholders also, as per this section number 235. Okay, since 9/10 of value of shareholders are ready to sell, the section number 235 gives right to the transferee company to purchase the shares of even dissenting shareholders also. Okay, so in this situation, then send a copy of notice along with instrument of transfer to transferor company to be executed on behalf of dissenting shareholders. Now, in order to transfer shares of the shares from the shareholders, you will be requiring signatures of the shareholders. Now, dissenting shareholders, they don't want to sell the shares, so why will they execute this document? They will not sign the document. So in this situation, the transferee company is there, it has to send notice along with this transfer document to the transferor company, and transferor company will execute this document on behalf of its dissenting shareholders. Hope that is clear. And transferee company will pay consideration to the transferor company, since shareholders are not since some shareholders are not agreeing, their value of share will be paid to the transferor company. Transferor company will pay them to the shareholders within 60 days. Okay, within 60 days disburse that amount to the shareholders by the transferor company. Hope that is clear. Next, section number 238. Basically, under section 238, what it says is offer under section 235. That is, offer to acquire transferor company has been made. Now, this offer document has to be first of all registered with the registrar before giving the offer. as per section 238. See, offer under section 235 must be registered with the registrar, that is registrar of companies, ROCs. Registrar can reject it within 30 days. Appeal can be filed to tribunal against the order of registrar. Okay, once you file this offer document with the registrar, registrar is also having a right to reject this offer document. If registrar rejects this offer document, then you cannot give that offer document to the transferee company, to the shareholders of the transferee company. Hope that is clear. Next, section number 233, which deals with fast track mode of merger. Now, instead of going to all that procedure of section number 232, you can instantly merge the companies by following this fast track mode of merger. But however, this provision of section 233 is not applicable for all the companies. Only for certain specified companies, fast track mode of merger is applicable. So what are those specified companies? First of all, if merger is between two or more small companies, small company means paid up share capital not more than 4 crores and turnover not more than 40 crores. In such a case, that such company will be known as a small company. If merger is between two or more small companies, you can follow this fast track mode of merger. Or merger is between holding company and its wholly owned subsidiary company. Okay, holding company is merging its wholly owned subsidiary company, then also you can follow this section 233. Next, two or more startup companies are going to merge. Startup company means those company which are having startup registration with DPIT. Okay. Next, one or more startup with one or more small company. Okay, so for these types of mergers, the fast track mode of merger is applicable. Now, what is the procedure that will be followed here? Company 1, company 2. Okay, the both companies that they are going to merge, they have to give notice inviting suggestions. To whom the notice has to be given? To the registrar and the official liquidator. Okay, company 1 has to give, company 2 also should give to the registrar and official liquidator. Here, why official liquidator has come? Because let's say A plus B are going to form AB. Here, in this situation, A will be liquidated, B will be liquidated. Since they will be liquidated, they have to send this notice inviting the suggestions to their respective liquidators also. Hope that is clear. And after that, you have to get approval by members holding at least 90% of the shares. Okay, approval of the members is required. How many members? Members holding 90% of the shares. Here also approval of members holding at least 90% of shares. This procedure, it has to be done in both the companies. Next, approval by majority representing 9/10 value of creditors. Okay, creditors approval also required. Here, creditors approval is dual in nature, majority in number and 9/10 in value. Same here also, approval by majority representing 9/10 in value. After the required approval is required, you have to file copy of scheme with central government, registrar and a liquidator. Now, if the registrar or liquidator is having any objections to the scheme, in such a situation, communicate to central government within 30 days. Okay, registrar and the official liquidator, if these people they are having any objections to the scheme, then they have to communicate those objections to the central government within how many days? Within 30 days. If central government, based on objections, central government also feels that scheme is not in the public interest or creditors interest, in such a situation, what the central government will do is, central government will order the company to take up this merger under section 232. You follow the regular route. Okay, here some objections are involved. The amalgamation is not in the interest of the public or not in the interest of the creditor, so you please follow section number 232. You come in that route, like the central government will order. In case the registrar and the official liquidator are having no objections, in such situation, central government will approve the scheme and communicate copy of order to the registrar of companies. Okay, so this is fast track mode of merger. By this, we have completed discussion of this entire chapter, compromise, arrangement and amalgamation. Okay, we'll be meeting in the next class with a new chapter. Until then, take care. Bye bye. See you.